Thank you very much, Mr. Speaker. Mr. Speaker, I want to thank all the members who have given their solid and unreserved support to this amendment or these amendments. But there are a few matters, Mr. Speaker, that I want just to put on the record briefly for the completeness of the discourse. Mr. Ramjatan has made reference to it, Honorable Member, and my colleague, the Honorable Member Sanjeev Dattadin, made reference to it as well. And Mr. Speaker, it has to do, in particular for the non-lawyers, why this such what appears to be a patent violation of judicial independence being expressed in Section 72 was allowed to remain on the record for such a long time. My distinguished sister, the Honorable Unesh Waldron, indicated that the Criminal Law Procedure Act, the substantive act, was enacted in 1893. Section 72 was one of the original sections in that act, and then it was once amended in 1973, 100 years after. But in a minor way, and we have it now in its current form until we change it. So why we became independence in 1966, and our constitution was then promulgated, and it declares itself to be the supreme law. It ensconces the separation of power doctrine. So how then did a provision that appears on its face to be so flagrantly in violation of natural justice, of undermining the judiciary, escape the eyes of so many great judicial minds and legal forensic minds that our country has produced, and undoubtedly so? And it has to do, Mr. Speaker, with the existence of a provision in our Constitution which is normally referred to, and it's a provision that exists in all Commonwealth Constitution. It's the Saving of Existing Laws Clause, and it says essentially this, that all laws that were existing prior to the coming into force of the Constitution are saved, notwithstanding the fact that they may be inconsistent with and in collision with the Constitution. So, pre-existing constitutional laws were allowed to be inconsistent with the Constitution by the Constitution itself. But future laws cannot be inconsistent with the Constitution because they would be unconstitutional. That is also in the Constitution. So, this issue of this collision that arose in relation to Section 72 has arisen many times before. So in the case, I have a case here of Degar and Cox. This is Peter Degar campaigning in the interior. This is a case that is reported in the West Indian Report, 1971, 18 West Indian Report at page 44. Mr. Degar was campaigning using a loudspeaker in the interior, and he was charged with violating the Amerindian ordinance at the time, which says that one can't enter Amerindian communities without permission. Now, Mr. Degar, and he was charged, and that was an offense. Mr. Degar invoked properly so his constitutional right and said, look, I have freedom of movement any part of this country. And that freedom of movement is guaranteed by the supreme law of Guyana, the Constitution. How can you tell me that an Amerindian ordinance, which is an inferior law when compared to the Constitution, can take away my constitutional rights? And a court comprising of Chief Justice Bullers, Justice George, and Justice Messiah, Justice of Appeal, powerful court at the time, ruled that because the Amerindian Ordinance was a 1957 ordinance, it predates the Constitution, and by virtue of the saving of existing laws provision in the Constitution, it is allowed to be inconsistent with the Constitution. So that is how they answer the question. I think Mr. Ramjitan made reference to the case of Williams and Salisbury. Again, 1978, page 1978, 26 West Indian Law Report at page 133. Again, Section 72 itself came under review. The quorum at the Court of Appeal at that time was Chancellor Haynes, regarded as possibly the greatest judicial mind we have produced, or one of. Justice of Appeal Crane, Justice of Appeal Messiah. This is a powerfully constituted bench when it comes to criminal law and constitutional matters. The issue was raised. Tangentially, however, it was not a matter for them to determine. But they all recognized, as Mr. Ramjitan said, and as Sanjeev said, the honorable member, that Section 72 collides with the doctrine of separation of powers. It undermines judicial independence because a non-judicial organ is directing a magistrate on how to determine a matter. And they found it to be inconsistent with the right to a fair trial before an impartial and independent tribunal. But they all said, all three of them, that it's a pre-existing law clause that we can't interfere with. Fast forward to Attorney General against Ramlochan. This one here is 83 West Indian Report, 2014. In this case, Ramlochan was charged with being in possession of stolen items. Now, the provision in the Criminal Law Offences Act in relation to this offense reverses the burden. You see, when you are charged with a criminal offense, you are presumed to be innocent until the prosecution proves you guilty. Here, once you are found in possession of a stolen item, you are presumed to know that it is stolen, and you now have to rebut the presumption. So they reverse the burden. That burden is recognized and enshrined in the Constitution. If you look at Article 144, every person charged with a criminal offense is presumed to be innocent. But here it is, a person charged with this offense is presumed basically to be guilty. So they challenge the section. Yours truly was the Attorney General. I appeared in the Court of Appeal and advanced the very argument that it is a pre-existing law and therefore it is saved by the Constitution. The learned Attorney General, Mr. Nandlall, forcefully argues that Section 94(1) was an existing law at the commencement of the Constitution, and the present time continues to be part of the laws of Guyana. And nothing contained under the authority of that law can be unconstitutional. And the judges said it is a contention with which we fully agree. But yes, it was repugnant, except saved by the existing laws. So this is what the point I want to make. This is what the court said at the end of its judgment. The role of the court is not to make law, but to interpret and apply it. Not to make law, but to interpret and apply it. However, the people of Guyana are entitled to benefit from the full range of fundamental rights and freedom guaranteed to them under the Constitution. The saving of pre-existing laws, as the instant matter illustrates, results in a diminution of the benefit and protection of those fundamental rights. The time is therefore well nigh due in this, our fully independent and sovereign republic, for our legislators to take appropriate action with respect to the saving effect of Article 152 of the Constitution in relation to pre-existing laws which conflict with the constitutional guarantees of fundamental rights. Our Court of Appeal is saying it's a matter for this House. The CCJ has parted company. And the CCJ, our courts, we are bound by it, our apex court, they said that they are not going to wait. They will strike it down using their power of interpretation, because they have a duty to modify the law by interpretation to bring it in conformity with the Constitution. But there are limits to interpretation. You can't interpret this to be a Mercedes-Benz motor car. You can only interpret as the elasticity of the language allows you to, because you are interpreting. And that's the point that the Court of Appeal was making here. Legislators must do what legislators are allowed and permitted and authorized to do in the Constitution. The Privy Council, in a case called Chandler, recently determined, had to confront the same matter, identical issue arising out of Trinidad and Tobago. And the Privy Council said, we are not going to interfere with that matter. As long as the savings of existing laws remain in the Constitution, we as the Privy Council, as a court, we are to obey it and interpret it. It's a matter for the politicians and the people of Trinidad and Tobago to change it. So you have this very opposed position of the two courts of appeals in the region on a matter that is of fundamental importance to the people of the Caribbean. Because you have less than half of the territories, their appellate court is the Caribbean Court of Justice, and more than half is the Privy Council. And you have this diametrically opposed jurisprudential position that confronts us. However, we are bound, whatever justification the CCJ has come up with for their position, we are bound by it. And I have my concerns, which I raised with the President of the Caribbean Court of Justice when I met with him. And I told him that when the bill is going to be debated, I will raise these concerns. But they are our final court, and we respect that, and we are complying with their directions. So the Honorable Member Gita Chandan has raised an important point, and I want to take it on board, which is, although, as I said, we consulted with the DPP, and the DPP did not find objectionable the 3 months period, I believe that sometimes you may have a recalcitrant delinquent magistrate, or the system may simply be one that delays the process and frustrates the 3 months period that the DPP has from being complied with. So I will move a short, brief amendment in relation to that, and we already have two amendments already that I will ask your permission to move at the appropriate time. So, Mr. Speaker, I believe that we have corrected a major deficiency in our law as declared by the Caribbean Court of Justice, and I am happy that both sides of the House have recognized the importance of correcting this, and though we may have nuanced difference in our forensic examination of how the CCJ dealt with the matter, the bottom line is that we recognize that it is our final court and its rulings are binding upon us, and we are acting in compliance as a parliament with those directions from our apex court. So, Mr. Speaker, I would close here and I will ask that the bill be read a third time.
Second time. Thank you.
A second time, sorry.
Thank you, Honorable Attorney General and Minister of Legal Affairs.